be. But I believe based on the rules, if I have a financial hardship and continued representation, the court would take that in as a reason for withdrawal. But more importantly, if I can withdraw at a time which will not create any kind of substantial hardship on behalf of the defendant, and I think that would be the case here. We do have all the discovery that we think we're entitled to at this time, but we have not had a preliminary exam, and I don't believe that any of my clients' rights have been prejudiced.
And Ms. Johnson-Jackson, anything you want to say regarding Mr. Mullins' motion to withdraw?
Yes, I don't agree with it.
Pardon?
I don't agree with it.
Okay, what don't you agree with?
Just based off the that was provided to me in reference to, can I see your paper?
Absolutely.
The one that's under.
Oh.
It's in there, like, way down. The email that you sent me this morning.
You want the motion? You want the, didn't you read me something?
Yeah, that's what I'm talking about, the email that was.
Well, hang on.
sent to me. Thank you.
Mhm.
So this morning, the email that was sent, which is what I'm about to read, it says the defense counsel appear on behalf of the defendant with the understanding that defendant will be remitting forthwith to defendant counsel a retainer payment as agreed upon by defense counsel and defendant. The second one was defendant subsequently failed to remit said retainer payment, nor has defendant indicated when the retainer will be paid. 1 second. The third one is an attorney may withdraw if his client fails substantially to fulfill an obligation to the lawyer regarding the lawyer services and has given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So in reference to all that, yeah, in reference to all that stated, the retainer, so him and I, it seems like there is confusion between him and I in reference to the retainer fee and just like the distance of my case. Does that make sense?
No.
So I don't agree. So what he's doing is a motion, right?
It's a motion to withdraw as your counsel.
Right. So I don't agree with the motion to withdraw in reference to this being, this is my probable cause hearing, right?
Well, it is a probable cause hearing, yes.
Right. So, okay, so I have a question. So with him withdrawing as my counsel, are we still doing this today or is that postponed?
If he withdraws, okay, ma'am. So I have to make a determination as to whether or not there are grounds to withdraw as
Understood.
I'm looking at it. So I asked, Mr. Mullins stated his position. I have the motion in front of me, and I'm asking what your position on this motion to withdraw is.
Oh, I absolutely disagree. And to my understanding, it seems like most of so like videos and just maybe more statements have been given to my defense, but I don't, to my understanding, that is the discovery, but I don't know anything about it because him and I haven't spoke about it. Does that make sense?
Okay, it could, yes.
Okay.
So, ma'am, let me just ask you this. His basis of withdrawing is that you were supposed to, you had certain financial obligations. It's indicating that you haven't fulfilled those. I don't need to know what those specific terms are because it's not relevant to at least the court's determination at this point. Are you indicating to me that you did fulfill those obligations? And
Yes.
therefore, okay, but fully fulfill those obligations?
I haven't fully fulfilled obligations, but I have put money in his hand. So that's why, yes.
Okay,
Jenna, may I respond just, or do you want me just to be quiet?
go ahead, go ahead.
Yeah, she's right. She's paid me some money, of course. But the reality of it is it's less than a third of what the retainer understanding was an agreement for this case. In addition to that, I haven't paid anything in almost 3 months. There's been no efforts to pay me. I've had multiple meetings. I had a meeting on the 26th of June specifically to make this a focus. I don't like talking about money. I'd rather work as a lawyer and do the work on the case and have those meetings. But as you know, it becomes a conflict of interest when you're not being paid. This is a capital case. She's entitled to substantial work on this case as it being a capital case. And when I'm not getting paid, I don't know how I'll be able to do it. This is not like an OWI where even if I'm not getting paid, I could probably suffer through it and it wouldn't damage my practice or my mental health. This would be maybe a little more of a different of a situation. But to say that she hasn't paid me any money,
I don't think that you said that.
I just want to make it clear she has, but she has not even come.
That's not what I got from this. I get it. So, ma'am, are you telling me? I understand that you've paid part of what's there,
Yes,
okay? But you haven't paid what the entire amount agreed upon was.
you said what the entire amount?
What the entire amount, you haven't paid that.
I haven't paid the entire amount.
Okay, so are you telling me that you're going to?
What I'm saying is there has been some confusion in reference to the amounts. There has been efforts, multiple efforts to make payment, and I have made payment. I have not made the entire amount. But
So
my
ma'am, let me just ask you this. As to the entire amount that was requested to obtain of the retention, why hasn't the full amount been paid?
because there was confusion on the full amount.
Your Honor, Ms.
I don't know what that means.
Miss Jackson Jackson wrote me out a payment schedule. This was her schedule. It wasn't my proposed schedule.
Yeah.
She wrote me out a payment schedule and provided it to me and has not even lived up to that. And like I said, less than a third of the retainer in the case. And just so this court knows why I'm a little nervous on top of it is, and I explained this to her, I have a bifurcated billing system. Part of it's a retainer, that's a flat fee. The other part is an hourly when we get into motions and trial. And the fact that we're having such an issue with just the base retainer, I'm nervous. We go further in this case. We get into trial, we're going to have an hourly bill that's going to be accumulating, and I don't have confidence in that bill being paid timely. So hence the motion.
Ma'am, is he right? You laid out an agreement that you were gonna pay?
We did have an agreement,
Ma'am, can I ask you why you just don't answer my question?
because
I think my questions are rather simple. Mr. Mullins has indicated you laid out a payment schedule to him. Is that right?
yes, but it wasn't the total amount being asked. The payment plan that was laid out was not the total amount that is requested. And so when I understand, when I say that there is confusion in reference to it, usually, for instance, people will sign a retainer fee with the lawyer, and that didn't happen. So once again, I did give him money to counsel me. But as far as the total amount, it wasn't.
Then ma'am, explain to me something.
Mhm,
If you haven't done that part,
mhm.
why shouldn't I grant his motion and just let him withdraw?
Because this is the probable cause hearing.
Because what?
This is the probable cause hearing.
Okay, and I give you another probable cause hearing. You won't be in any worse position
Mm. Okay,
because that's his obligation. His obligation is not to put you in a worse position when he goes to withdraw. And so that you understand what Mr. Mullins is really saying, and maybe he says just more fancy way than I would. He doesn't want to get to the point where either you're not paying him or something else happens in the case, and then he's either stuck because he can't have you in a safe spot, or he just has to try to get out to save himself, and you're going to be in a worse spot.
I understand.
So can you tell me a reason why I shouldn't let him out?
So I have a question. Can I ask a question?
Sure.
So let's say that you rule that he in his favor. So so I would be given a,
Ma'am, let me stop. I'm going to tell you what I'm going to do. Okay? And that way we can just put this to an end. I'm going to grant his motion to withdraw. I get it. I think you're a little bit worried that you're going to be left out there on your own. Here's the PCC and whatever. Doesn't work that way here. So I'm going to grant Mr. Mullins' motion. Mr. Mullins is withdrawn from the case and further discharge of any obligation of this client or the court on this matter.
Thank you, Your Honor.
This now becomes a public defender case. You're represented by the public defender at this juncture, okay? That way you still have counsel, very capable counsel to represent you in this matter. Ms. Anderson, thank you.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Johnson Jackson. Your Honor, I asked for a couple weeks adjournment for us to get discovery and speak with her about the case.
All right. All right. Probable cause conference in this matter will be adjourned to July 25th, 2024 at 9 a.m. or as your invite indicates. Okay? Ms. Johnson Jackson, you understand?
yes,
Okay, so you've got counsel now. They'll get the discovery. They'll be able to go through it with you and pace through it. It doesn't mean if you want to hire another attorney or somebody else, you can still do that. But you've got very, very capable, extraordinary counsel to represent you. So,
I understand.
okay. And so bond will continue.
Thank you, Your Honor.
Thank you.
Oh, okay. Mr. Kittle, I thought that was it.
We're ready. Oh. We've been ready for the last half. And then the judge came charging off the bench. All right.
What you just watched may not look explosive at first glance. There were no shouting matches, no handcuffs snapping shut, no dramatic outbursts that make a courtroom instantly viral. But make no mistake, this hearing mattered a lot. Because beneath the polite tone and procedural language, this case exposed one of the most uncomfortable truths in the criminal justice system. When money, misunderstanding, and timing collide, even a defendant's own lawyer can walk away. The case opens routinely enough. The court calls People versus Kesia Johnson Jackson, and within seconds, it becomes clear that today is not about guilt or innocence. It's about representation, specifically defense counsel's motion to withdraw. From the very beginning, the judge frames the issue precisely. This is a probable cause conference. Early stage, no trial yet, no evidentiary hearing completed, and that detail becomes crucial later. Defense counsel calmly explains his position. He's not emotional, he's not hostile, he's careful. He tells the court that he's laid out the important facts in his written motion, and that he's happy to provide further detail if necessary. Then he goes straight to the heart of the matter, financial hardship and ethical obligations. This isn't a lawyer storming off. This is a lawyer invoking the rules. He explains that continued representation would create a financial burden and potentially a conflict. More importantly, he emphasizes that withdrawing now would not create substantial hardship for the defendant. That phrase isn't accidental. That's legal language. Because under professional conduct rules, an attorney can't just walk away whenever they feel like it, especially in a serious case. The court has to ensure that the withdrawal won't leave the defendant worse off, and then the judge does what good judges do. He turns to the defendant. Miss Johnson Jackson is asked whether she agrees with her attorney's motion. Her response is immediate and firm. I don't agree with it. That single sentence changes the tone of the entire hearing. Now, this isn't just a procedural withdrawal. It's a contested one. The judge presses further. What exactly does she disagree with? And here's where the confusion begins to surface. Miss Johnson-Jackson references paperwork she received that morning. She asks to see the motion. She begins reading from it herself. She points out that the motion says she failed to remit the agreed-upon retainer payment. She references the rule stating that an attorney may withdraw if the client fails to fulfill financial obligations after reasonable warning. And then she pushes back. She says there has been confusion regarding the retainer, confusion about the amount, confusion about expectations, confusion about the structure. She insists she has paid money. She insists there were efforts to pay. And most importantly, she emphasizes the timing. This is her probable cause hearing. She's worried about what happens next. That concern is real. For a defendant, the idea of losing your lawyer, especially even when a public defender is available, the fear of starting over, of delays, of missed strategy is very real. The judge listens patiently. He doesn't interrupt, he doesn't lecture, he allows her to speak. Then he does something critical. He narrows the issue. He explains that the court does not need to know the specific financial terms. That's not the court's role. The court's role is to determine whether the attorney has grounds to withdraw and whether doing so would prejudice the defendant. So he asks a simple question. Did you fully fulfill your financial obligations to your attorney? And here's the moment that quietly seals the outcome. She answers honestly. No, I haven't fully fulfilled the obligations, but I have put money in his hand. That distinction matters emotionally, but legally, it changes very little. Defense counsel then responds, and this is where his explanation becomes decisive. He confirms that she has paid some money. He makes it clear he's not denying that, but he states plainly that it's less than 1/3 of the agreed retainer. He hasn't been paid in nearly 3 months. He's had multiple meetings trying to resolve it, one as recently as late June. And then he says something many lawyers are reluctant to say out loud. This case is serious. It's capital level serious. It requires substantial work, time, and mental investment. This is not a simple misdemeanor where a lawyer can absorb unpaid hours and move on. Continued representation without payment doesn't just strain his finances. It risks his ability to do the job ethically and effectively. He explains the billing structure, part flat retainer, part hourly once motions, and trial begin. And if there's already a breakdown at the retainer level, he has no confidence that future hourly billing would be paid. That's not greed, that's realism. The judge absorbs this and turns back to the defendant. He asks again, was there an agreement? She says yes. He asks whether she laid out a payment schedule. She admits she did. And defense counsel confirms that she hasn't even met that schedule. Now the judge shifts from fact-finding to consequence. He explains something extremely important and extremely misunderstood by many defendants. A lawyer's obligation when withdrawing is not to stay no matter what. It is to ensure the client is not left in a worse position. And at this stage, a probable cause conference, the court can reset the hearing. The defendant will not lose rights. She will not be forced to proceed alone. The system has safeguards. Then the judge asks the most direct question of the entire hearing. Can you tell me a reason why I shouldn't let him withdraw? This is the defendant's opportunity to give the court something concrete, something legal, something compelling. But instead, she asks another procedural question about what happens next if the motion is granted. And at that moment, the judge decides the issue has run its course. He stops the back and forth. He explains exactly what he's going to do and why. He grants the motion to withdraw, not angrily, not dismissively, matter-of-factly. He acknowledges her concern about being left alone and immediately resolves it. The case becomes a public defender case. She will not be unrepresented. She will have capable counsel. The probable cause conference will be adjourned. Discovery will be reviewed. Her bond will continue. In other words, the system closes the gap. A public defender steps in on the record. She requests time to review discovery and consult with her client. The judge grants it. A new date is set. And just like that, the moment passes. No shouting, no drama, just consequences. But here's why this matters. This hearing shows the reality of private representation that many defendants don't fully understand until it's too late. Hiring a private attorney is not just about strategy or reputation. It's a contractual relationship. When payment breaks down, representation can break down with it, even in serious cases. It also shows the court's balancing act. Judges are not there to force lawyers to work unpaid indefinitely, nor are they there to abandon defendants. Their role is to ensure fairness on both sides. And in this case, the judge did exactly that. The defendant wasn't punished for her inability to pay. She wasn't shamed. She wasn't lectured. She was transitioned to a public defender, someone trained, qualified, and obligated to represent her interests fully. This wasn't chaos. This was process. And perhaps most importantly, this hearing is a reminder that courtroom drama doesn't always look dramatic. Sometimes it looks like quiet disappointment. Sometimes it looks like paperwork and timelines. Sometimes it looks like a lawyer saying, "I can't do this anymore, Mom." Not ethically, not responsibly. And sometimes justice moves forward not with a bang, but with a reset. Because when the judge closed this matter and called the next case, the system did what it was designed to do. Keep moving, keep balancing, keep protecting rights, even when the situation is uncomfortable. That's the courtroom reality most people never see. And now you've seen it.